Good evening. This is John Milburn for LAWS12062. This is Alternative Dispute Resolution. We're into week 12 of term 2, 2019. So it's our final week. And this week on Thursday, I release the take-home paper. More about that shortly. In the meantime, I have something that I wish to urge upon those of you that are here and watching this as a recorded session, which hopefully means everyone in the unit. And that is, if you haven't already done so, please provide feedback. Let me share the screen. We have at the moment an unfortunate record, at least as far as my records are concerned. And I'll stop the share because I'm not sure what's come up there on the screen. I'll try again. What I'm looking for, I've got, as you might tell, I've got a lot of screens open at the moment. Not to worry, what I'll do is I'll just indicate that we have at the moment only 6 of 53 have had their say. So you'll see the top left-hand corner of the Moodle landing page. So please, we need to work on that. The university expects that I will have 50% of the students provide feedback. So I've got to move that number from 6 all the way up to, what's that, 27. So please, the next few days, if you haven't already done so, have your say. It's very important for the university, and as you might expect, it's very important for me. So enough about that. Now the take-home exam. I should indicate that usually in week 12, I'm doing some review work, but I'm also providing you with information about the future of ADR and restorative justice and some other more specific issues around ADR in land court practice and some other specialised areas such as hybrid hearings. So the good news is that I'm not covering those areas tonight. You're welcome to ask any questions and I'll cover it if you like. But I want to let you know that they're not part of the exam. So when I talk about everything that we've covered being examinable, even though those areas are referred to in the notes, you won't be examined on those issues, which is quite different to usual years. So it seems to me that the best way that I can assist you in preparing for Thursday is to look at the information guide that I prepared for this year's examination and then walk you through some of the past examinations. So I've been involved in this unit since I think 2013 or 2014. So I've written all of the take-home papers that are uploaded, and I've uploaded the 2018 paper. You may not have seen that. So before I start, are there any questions about what I propose to do tonight? Does anyone want me to cover restorative justice and some other issues that I mentioned that I don't propose to cover? All good? Okay. Well, let's move into the information guide that I provided. Now, those of you that have joined me live, thank you very much for doing so. And I suspect that you have read this carefully. Likewise, those of you that are joining, watching this as a recorded session, I'm sure that you've seen this as well. Now, for some reason, I'm just not getting, you're probably seeing a whole range of things on the screen. And I don't know why I'm not being able to isolate successfully just the 2019 paper. So I'll try again. And Gary, yes, I've just put the 2018 paper on Moodle under the assessment section. So my apologies for this delay. Let's hope that I can get this now.
While you're doing that, John, just a question.
Yes.
Your 15 and 16 paper, they were extraordinarily long questions.
They were. And there's some
We've
reasons
moved away
for
from
that. What's that, sorry?
We've moved away from that because that was like...
It was tough, wasn't it?
Yeah, very long. I was looking at, and then, you know, it's moving a bit more from ADR. That was my opinion. I could be so wrong.
Yes. You know? So the attempt there in those years, 15 and 16, was to have a practical application of a certain type, and that was in relation to parties involved in a dispute situation. I guess for the exam, there are three basic types of questions, at least in my mindset when I'm writing a take-home paper. Number one is writing a paper which requires you to look at an existing dispute and to come up with some strategies and some ideas about how to use ADR platforms to resolve that dispute. Now, of course, I need to give the dispute some substance. And in a way, it doesn't matter so much what the dispute happens to be about when I'm examining you in that way. So we'll talk more about 15 and 16 shortly, but that's one type of exam. The second type of exam relates to you creating some sort of structure around planning. So using, say, the construction industry as a guide, how do we create an ADR program that provides for the needs of the client and provides for flexibility? So that's kind of the second type of question. And the third type of question is probably that relates to the issues around accreditation and compliance, things of that nature. So they're kind of the three broad areas. Does that make sense? Does anyone have any comments about what I've just said? All good? All right. So let's have a look at the take-home paper. You've seen the information guide. You've read it. You know that you have 29 hours, thereabouts, to answer the problem. I'll release it on Thursday, the 10th of October. It will be at 6:30 or as close to 6:30 as I can. Please submit your work by Friday the 11th, 11:45 p.m. No late submissions accepted. I can't accept it. The system will literally lock you out, and there's no 5% penalty for 1 day late, things of that nature. It's all or nothing on this one. The first question is a hypothetical scenario reflecting on the work. That's very broad, and that could be either of the first two types of questions that I mentioned to you. The second question is more an essay question, so that could be more likely the third type of question that relates to issues around compliance. But whatever question that you have, please think about ethical issues always, and then think about statutes, case law, practice standards, rules, regulations, practice directions, all of those things. Now, you understand that this is a substitute to an invigilated examination. So as a result of that, I won't provide you with any feedback that is personalised, but I will provide the class with general feedback. The decision that I've made, and I've mentioned this to you earlier, is that you may consult with your peers at your discretion, and the final answer must be yours, but must be yours. There is a 2,000 word limit, so try to stay with that. Don't go too much beyond it. If you find yourself well below it, which might surprise me, but if you do, then please, I'm not going to use the word pad, but please value add to some degree, because you might add something that you think is not entirely relevant, but I might see some value in it and award you additional marks as a result. So do have a look at the way in which I mark the assessment by reference to the assessment criteria and in particular to the rubric. All right, any questions then about the information guide for this current year's examination? All fine? Good. Let's move on to, in reverse order now, the take-home paper from 2018. So this paper, which of course was last year's paper, had a particular theme to it, which was certainly very different to the earlier themes of 15 and 16 that were difficult papers. I should mention that when I mark papers, I do so by reference to the degree of difficulty. So if you find yourself this year presented with a really, really tough paper, don't panic, because you'll understand that I mark accordingly acknowledging that it's a really tough paper. In some ways, your worst nightmare will be if you open the paper and think, this is easy, because it's then got to be something special to get some very good marks. I hope you understand what I mean. So the paper last year was similar in format in some ways to the paper this year, in that the students had 29 hours to complete the task, similar word count if not the same marks, same basic conditions, same type of assessment criteria, and similar rubric. Now this was, in question 1, the second type of question, where your task was to take a hypothetical scenario and to devise an ADR practice system that works for that particular scenario. And it was based around property and construction, marketing, and it had a ministerial aspect to it. So it was government type work in the context of that industry. So your task there was to prepare a document that emphasizes practical solutions. If you get that type of question in the exam this year, I really do want it to read as a practical document. And when I'm writing a question like this, I'll try to frame it in such a way as to give you an idea of what I seek by reference to the recipient, the hypothetical recipient. So in this case, in last year, you were to prepare a ministerial briefing paper. So the ministerial briefing paper is not one where you're going to add a great deal of, if you like, theoretical information, background information and definitions. Your task in a very limited word count is to get straight to the point and offer real solutions to the problem. So I hope that makes sense. And that's a pretty common type of question for me to write. So that's the sort of thing that you may get in question 1 this year. So practical, process orientated, not too much theory, but you would normally expect in a good paper to see reference to the theory, footnote referenced, rather than taking up the text. You know, NADRAC defines mediation in this form, taking up 300 words out of 1400 is not the sort of thing that I'd expect. So any questions there as a result of that commentary? All good? Okay. And the second question related to restorative justice, which of course you won't have now. But again, you'll see that common theme of asking you to consider ethical issues amongst other things when answering any type of question in relation to ADR. So that was the paper that I set in 2018. It might be worthwhile considering some of the aspects of that beyond what I've said in terms of the sort of response that I'd be seeking. So in that regard, I was looking for you to provide an understanding of dispute prevention and to recognise that dispute prevention is a form of dispute resolution. So that's particularly relevant for those that are involved in dispute prevention and designing a dispute resolution process within that context. The reality is that disputes can't be entirely avoided, but if you have a question that relates to designing a dispute prevention and resolution process, then what you're doing is acknowledging the existence of disputes as likely and building in processes to prevent or resolve. And that's a key. Prevention on the one hand, or minimization, and then on the other hand, resolution. And I think you'd need to build in both of those things if you're designing a prevention and resolution process of the sort that the Minister wanted you to last year. Again, practically orientated and something that can be acted upon at an early stage, effectively minimise disruptions. They're the kind of key elements, aren't they? You need to build in a process that allows for people to have an opinion and voice their opinion, and do so preferably before it escalates into a full-blown dispute. For that reason, if you're designing a process, it's likely that you'll build in more than one aspect to it. So it's not likely that you would simply select one form of ADR process. You'd probably develop some sort of hybrid process, something that best meets the needs of the client in that theoretical situation. In other words, you can be very creative. You can come up with interesting and original approaches to the task. So if you're confronted with that type of paper, it's very unlikely that you'll be able to Google a response, because odds are there is no one response available. Good news is that you can come up with a completely different idea to that which I had in mind and still do very well. The idea that what I'm looking for is evidence that you've read widely, that you've demonstrated an understanding of the reading, and of course, if you do refer to material, as I'd hope you would, do reference that material in your paper. So in the paper that you had, or that the students had last year, it was a relatively large-scale process. It can be a mega process, like a hospital in Hong Kong type deal, or it can be a micro or mini type dispute resolution process. So I think in last year's paper, a lot of students wrote about dispute resolution advisors, dispute resolution boards, partnering, that type of thing, and created a hybrid system, interposing mechanisms for the resolution of the dispute, and possibly in terms of dealing with the dispute resolution aspect of it, introducing things like expert determination or perhaps even early neutral evaluation. So that was the kind of thing that I had in mind, and where most of the good answers took me in terms of a resolution. But they all had a practical flavour to it. All right, so, and of course, many of the students, I think quite sensibly, introduced mediation into that process as well. So when we look at the paper from last year that you've only just seen now, and the comments that I've made, firstly, is there any feedback, any comments, any questions about how you might go about answering this sort of question if confronted with it this year? All good? I know I'm doing a lot of talking, but if you have any questions, please interrupt. All right, so that was last year's, and I won't worry about restorative justice. So let's have a look at the paper from 2017. Share the screen. Find the paper, hopefully. No. If you've got access to it, please have a look at that on your screen. I know it's here somewhere. I'm sorry, I was very ambitious in having so many screens open on my computer. So what I'll do is I'll invite you just to call it up on your own screen. Now the 2017 paper, again, was similar in format, but there were 3 questions. The first one talked about court annexed ADR. It was an essay style question, but it was around statutory dispute resolution processes. So the question said, Justice French said, it is in the public interest that the constitutional function of the judiciary is not compromised in fact or as a matter of perception, and then goes on to talk about ADR in the context of judicial process. And then we've got a reference to Deputy President Kingham of the Land and Resources Tribunal, as Her Honour was at that stage. So that's really a theoretical type question, but it's around case management issues. So the question this year might relate to something to do with case management in the court system, but within the context of a practical or problem. So it might be something in that regard. If you do find that you have a question in relation to that issue of case management and the court system, then some things that you want to consider are the sorts of courts and tribunals that adopt ADR practices generally, the way in which case management is used as a tool in the resolution of disputes. You need to consider issues around why we have case management tools. Well, probably, fairly obviously, I guess, to resolve disputes, but also at the same time minimise court backlog. The case management tools can be something that is voluntary, or it can be imposed as a result of the court system. And many of the processes require some degree of oversight by the courts, and the courts may have some direct involvement in full or part in the process. If you're thinking about this type of question, don't forget the Uniform Civil Procedure Rules in Queensland. And a good one to have up your sleeve, even if you just footnote it, is Rule 5, and it deals with the overriding obligations of parties and a court to facilitate the just and expeditious resolution of the real issues in civil proceedings at a minimum of expense. Note also Part 4 of the UCPR that deals with alternate dispute resolution processes, and note Part 6 of the Civil Proceedings Act 2011, because that provides for ADR processes as well. So there's some of the things that you would probably want to refer to, even if you're just footnoting, if you have a question around case management type issues. A litigation option that's always worth considering is arbitration. And if you're considering arbitration in a commercial context, or in fact, a context probably other than family law, you'd probably look to the Commercial Arbitration Act 2013 Queensland. And do note Section 71 of the District Court Act, District Court of Queensland Act 1967 provides a judge may refer a matter to arbitration if reasonable. The Supreme Court has a procedure to initiate case appraisal mechanisms, and magistrates have power to refer disputes to conciliation. So look at the Magistrates Court Act 1921, Division 2. Now, QCAT, the Queensland Civil and Administrative Tribunal, in its act, the QCAT Act 2009, provides for QCAT's charter to resolve issues in a manner that is accessible, fair, just, economical, informal and quick. And if you're referring to the Act, you'd probably also refer to the regulations, or the rules rather, which is the QCAT Rules 2009. For example, look at Rule 3. Now, it may be that the question that, if you do get a question around case management and court annexed ADR, it may be federal based. It might be to do with the Native Title Act. So the Native Title Act, Section 31(1)(b), requires parties to negotiate in a way that is such that they're doing so in good faith. And we see that type of term in a lot of legislation. So, for example, the Migration Act 1958, the Fair Work Act 2009, and the Civil Dispute Resolution Act 2011, all Commonwealth, have reference to that. Very importantly, in terms of overriding obligations and philosophies in a federal sphere, we have the Federal Court of Australia Act 1976, and you would want to look at sections 37M, N, and P. 37M deals with the overarching purpose of civil litigation and procedure provisions to facilitate the just resolution of disputes according to law, but to do so as quickly, inexpensively, and efficiently as possible. 37N provides that parties are to act consistently with those overarching purposes, and parties' lawyers have a positive duty to assist the parties to comply with that duty. So it may be that if you have a question that relates to case management at a federal level or even a state level, it may be that you're to write this from the perspective of being a party's lawyer, advising them or making submissions to a court, or it may be that you are part of the process trying to resolve matters for litigants. But either way, you need to keep these overriding principles in mind. 37P provides for the power of the court to make directions in relation to it. All right, so if you're having trouble keeping up, I'm sorry I'm moving fast, but that's the Federal Court of Australia Act 1976, sections 37M, N, and P. When you look at these acts, always consider the rules that go with them. So the Federal Court Rules 2011 provide for the implementation of mediation and do so as a case management tool. The Federal Court Rules, or the Federal Circuit Court Rules rather, 2001, provide that if the rules are not sufficient, then you might look at the Family Court of Australia, the Family Law Act or the Federal Court of Australia Act to apply. Now, I mentioned practice directions, practice notes. So in the federal sphere, a relevant note is Federal Court Central Practice Note, which is CPN 1 of 2016. So Central Practice Note 1 of 2016. And it sets out the fundamental principles concerning the National Court framework of the Federal Court. Also look at Part 8, which deals with case management. So Parts 7 and 8 deal with issues of civil practice and mediation and ways of resolving matters quickly. Now, if you have a question that relates to family law, then of course you'd need to look at the Family Law Act at some stage. And the Family Law Act is geared up to assist the parties to resolve matters in a whole range of ways. Family dispute resolution practitioners and lawyers that practice in that space have clear statutory obligations to assist and manage their clients. So have a look at Section 11A of the Act, and it provides for the role of a family consultant. Also, consider Section 60I, and subsection 7 of that Act says that the court is not permitted to hear matters in relation to a child unless a valid certificate confirming a family dispute resolution has been attempted is obtained from a registered family dispute resolution practitioner. So on that score, also under the Family Law Act, look at sections 1F, 12E, that's E, 12G, and 13A. they're all sections, so it's 1F, 12E, 12G, 13A, they're all sections around the Family Law Act that relate to this space. And it may be that the question that you have for the take-home paper is about how to use the mechanisms within the family court sphere to assist in resolving the matter, or it may be issues around, well, how do I become accredited to be a practitioner in that field? Are there any special requirements? Always, again, and I'm sure it's a familiar theme now, if you look at an act, you must also consider whether there are any regulations or rules. In this instance, the Family Law Rules 2004 are relevant. So look at Rule 1.05, Division 28.34. So that's Rule 1.05, Division 28.34, and Part 28 and Schedule 1. Generally, in the federal sphere, look at the Federal Circuit Court of Australia Act, I mentioned it earlier, that's 1999, and consider sections 22, 23, 24 of the Federal Circuit Court of Australia Act. And finally, the AAT, the Administrative Appeals Tribunal, again, provides for reviews that are fair, just, economical, informal, and quick. Have a look at Section 2A of the Administrative Appeals Tribunal Act, 1975, Commonwealth. So the AAT at a Commonwealth level and QCAT at a state level share that basic philosophy, almost the same words, in terms of the way in which the processes should be undertaken. I know that's a lot of information, but I hope that you get the idea that if you're asked a question around case management issues, it is really a matter of trying to digest a lot of potential ways of resolving dispute, some of which can be ordered by the court, some of which can be controlled and recommended by the parties. Before we move on to the next topic of discussion, any questions, comments? Are you keeping up with me? All good? All right, thank you. Now, in question 2 of last year's paper, sorry, the 2017 paper, there was a discussion required about the enforceability of good faith negotiation clauses. And again, always consider issues around statutory provisions and case law. You'll see this a lot. Good faith negotiation clauses in contracts or court-referred mediation, or indeed in legislation. So you potentially, this type of question could either fall into the problem question or the essay style question, because we're looking at this from different perspectives, aren't we? So if it's a contract issue and there's an obligation to negotiate in good faith in the contract, then the question initially is, can it be enforced, or will a court strike down such a provision? So it may be that some clauses are regarded as too vague to be enforceable. So like the English approach, Walford against Miles, that was the approach. And you might recall last week or the week before, and I think Peter was involved in all of these cases, we talked about the decisions in Elizabeth Bay and Borrell. We talked about Aton and Transfield, and I think United Group Rail and Rail Corp. So remember all of that area of cases? That really is around that issue of good faith. And one of the issues is, if you're to negotiate with good faith, does that mean you have to help the opponent? Or can you comply with the obligation without forfeiting your position in deference to the other party? So there might be an essay style question around that. And there might be an issue of, well, can the parties oust the jurisdiction of the court? Can the good faith clause go so far as to say, sort of almost like collaborative law, we're going to resolve this out of court no matter what, and you just can't go to court? For a discussion around that, refer to Scott and Avery is the leading case. Now, if you have a good faith question, it might be, as I said, based around contract, which is what we've just discussed, or it may be around court annexed ADR. So this goes back to the earlier topic that we were talking about in terms of case management. So when we talk about court annexed or statutory based ADR practice, good faith is something that is very closely aligned with the obligation on parties to take genuine steps to resolve the dispute. I mentioned earlier at a Commonwealth level, the Civil Dispute Resolution Act 2011. In that regard, if I haven't mentioned it already, have a look at section 4(1)(a). That's the Civil Dispute Resolution Act 2011 Commonwealth, because it says, for the purposes of the Act, a person takes genuine steps to resolve a dispute if the steps taken by the person in relation to the dispute constitute a sincere and genuine attempt to resolve the dispute having regard to the person's circumstances and the nature and circumstances of the dispute. So again, this type of provision, section 4(1)(a), is an excellent one to have in your toolkit to at least refer to in a footnote reference to say, I'm aware of it, I'm aware of these obligations, but it may be the basis for a problem-based question, or it may be the basis for an essay-style question. Now, the overriding legislation and practice directions impose obligations to act in good faith. So I've mentioned the Administrative Appeals Tribunal Act. Have a look at section 34(a), subsections 3 and 5. I mentioned also previously the Central Practice Note, number 1 of 2016, under the National Court Framework and Case Management. All right. Whenever you're dealing with issues around good faith, and bear in mind for example, sometimes the legislation will define good faith, but the AAT Act does not include, for example, a definition of good faith. Other times, so therefore you need to consider, what do we mean by good faith? What provisions, practice directions, what guidance do I have? What cases do I have that might assist in that regard? Whenever you're talking about good faith in the context of ADR, a very good case to have up your sleeve and refer to is one we discussed last week, Legal Services Commissioner in Mullins, 2006 LPT 12. And you recall in that case, the court said that good faith was an implied expectation when participating in ADR process. So good faith may not even be expressly required under legislation. It may be something that is required impliedly, particularly for lawyers. All good? Before I move on, any questions, comments? Are we all good? All right, then we had, so if those papers in 2017 and 18 weren't difficult enough for you, then going back, we had the papers in 2015 and 16. I won't bring them up on the screen, but those of you that have read them gave me the feedback this evening that they were pretty tough, and they were. So let's have a look at the paper from 2016 first up, working backwards. So 2016 involved a hypothetical situation, a client, and working for that client to provide some responses and some options about mediation process. This question in 2016 was one where you had, or the students had, a good deal of time to resolve the issue. I think for one of them, they had a week to answer the question. So in case you're wondering why it was so difficult, bear in mind they had a lot more time to resolve it. And one of the, if not both of the questions was such that I encouraged participants to actually go and speak to ADR practitioners, to go out into the real world and get some ideas. So that's probably not something that you would do on this occasion, but it is something that I was encouraging at least at one stage before I cut the time frame down considerably. So in 2016, we dealt with a hypothetical situation and we were dealing with neighbourhood dispute. So you could think fairly widely. Always think about the Australian Solicitors Conduct Rules and obligations on solicitors. So in that case, I think there was some concern about whether the client could in fact provide lawful, proper and competent instructions. Whenever you see competent, you need to think about, we discussed this last week, guardianship and administration, the definition of capacity. Do we need to make an application to QCAT for someone to be appointed as an administrator or guardian to make decisions? So when we're dealing with neighbourhood type issues, then you might want to consider issues at a council level. And in this instance, there was the Environmental Protection Noise Policy of 2008 that provided some basis for making an approach and resolving the issue. Also, a neighbourhood mediation kit was relevant as well. Some students favoured a more determinative approach through arbitration, given the circumstances, than mediation or some other type of strategy. And of course, there was the issue of potential litigation as well. All right, so that's just a very brief overview of 2016. 2015 was probably the most difficult. That was the partnership dispute. Very involved matter, but fairly typical in the sense that we were dealing with a family issue. So certainly there's generally I suppose, a presumption that if we're dealing with a family issue, you want to try to resolve it outside the court system if you can. So I think in that instance, the best answers raised consideration for a number of options. Mediation, I think, is probably the first one that comes to mind. Some sort of a collaborative approach would also be relevant, probably underutilised outside of the family law system. Others went with arbitration. And remember, of course, that the Commercial Arbitration Act is not necessarily defined only by disputes that are commercial. It's actually much broader than that. So if you have something that is not immediately one that you think of commercial, it may well still be possible to introduce the Commercial Arbitration Act. General negotiations were relevant as well in that question. All right, again, that's a very brief overview of that paper, which just about brings me to the end of what I wanted to discuss for tonight in terms of technique and content. So are there any questions, any comments? All good? All right. Remember, of course, when you're writing your assessment, please follow the usual rules. You know that I can tell you the first thing I look to is just the overall presentation. So I want to make sure that it looks the part. It's not obviously cut and paste. Sometimes people give it away by having different fonts. So try to avoid that. Make sure it's paginated, properly footnote referenced, that you write in a style that is consistent with what I would expect. All right, so unless there's any questions, that's it for this unit. All good?
John, sorry, just one question.
Yes, Jack?
No expectation for a bibliography required?
No, no expectations. I don't mind if you add it, but it's certainly it's my view that we don't need it. And even though it is referred to in AGLC 4, generally speaking, in legal writing, you wouldn't include a bibliography. So you don't need that. You don't need a reference statement as well. So thanks, Jack. Anything else? Good. Okay, well, please, as I said at the start, do have your say. I'd really appreciate it. Otherwise, good luck on Thursday. And if there are any problems, you can send an email. I'll be monitoring the emails as best I can, particularly at the start, and or even send me a text, and I'll try to deal with that. Okay, all the best. Thank you very much for participating over 12 weeks, and all the best on Thursday. I hope everything goes well. Bye for now then. Thank you.